Well, I'm Steve Friedell. I teach torts, admiralty, and Jewish law. In the past year, I was cited, or my scholarship was cited by two Supreme Courts of two different countries, of our own country, United States Supreme Court, and of the Israel Supreme Court. The U.S. Supreme Court cited me in a case involving a houseboat. The question was really, was it a house or a boat? And the treatise had laid out what had been the rule for decades, for more than decades, that to be considered a vessel, a structure had to be intended to be used for transportation on the water, and this was really a man's home. The other case was in the Israel Supreme Court, and that involved a question of contributory negligence. And the court cited an article that I'd written almost 30 years ago. The court, and the author of the opinion actually, was himself a scholar of Jewish law, could have cited any number of Israeli authorities if he'd wanted to. They don't usually cite Americans on questions of Jewish law. You have, in this law school, you have a lot of people who are working on cutting-edge stuff, who are working on current events, current problems. And we're able to share that information with the students. And I think that that's typical of the law school, that we have a lot of scholars in a lot of fields who are regularly making contributions at all levels. One of the things I like to do is you should have fun. I mean, I don't think you should do anything in this world unless you enjoy it. So at the end of my torts class, and what is torts? Well, torts are injuries. There's a song that goes way back to William Prosser, who was the dean of the torts bar. And he apparently wrote this song, and law professors used to sing this to entertain themselves at their conferences. And I'll just sing you a little bit of it. Causation, causation, causation is not enough for me. Contributory negligence, assumption of the risk. They come up every time that you fall and slip a disc. But if you've got a lawyer with the proper song and dance, she might convince the jury that there was a last clear chance.